To RR Legal Talks. In today's video, we are covering a landmark development where the National Company Law Appellate Tribunal or NCLAT has sent back two major insolvency cases, ZW Marriott Bengaluru and Crown Plaza Pvt to the NCLT for re-examination. This is not just another order, it raises key questions about evidence handling, debt assignment, and the proper application of Section 7 of Insolvency and Bankruptcy Code. Let's dive in. The case background, the appeals, the company appeal 80 insolvency number 165 and 212 of 2024 were filed against NCLT orders admitting CIRP, Corporate Insolvency Resolution Process, against two prominent hotels, ZW Marriott in Bengaluru and Crown Plaza in Pune. The case originated from loan agreement dated 26 December 2017, under which GSTAAD Hotels Pvt and its subsidiary, Neo Capricorn Plaza Pvt Limited, borrowed funds from Piramal Capital Housing Finance Limited. The later debt was assigned to Omkara Asset Reconstruction Company. This led to CIRP proceedings under Section 7 of IBC, alleging loan default. The arguments by the appellant were loans were never classified as NPA. And another one, improper assignment, res judicata, repayment mechanism governed by cash management agreement, CMA. No misuse of ECLGS funds. So these are the 5 arguments by the appellants. We'll go through one by one. Loans were never classified as NPA, so they argued that Omkara couldn't initiate CIRP since the accounts were always standard, not non-performing. And another argument was improper assignment. So the appellant said the assignment of debt to Omkara was illegal and violated SARFASI Act and RBI circulars. Another argument was res judicata. So a previous Section 7 application had been withdrawn by IDBI Trusteeship Limited, and they argued a new application was brought. And repayment mechanism governed by a cash management agreement, that is called CMA. So this agreement, they claimed, showed they were serving loans correctly. And no misuse of ECLGS funds. So the appellants denied allegations of fund misuse, backing their claims with a forensic audit and documents. These were the arguments by the appellants. So the NCLT's findings and flaws. So the NCLT had admitted the CIRP against both hotels, essentially dismissing most of the above arguments. So critically, the tribunal rejected the existence of the CMA, cash management agreement, stating no evidence has been submitted. So it has also accepted the misuse of funds, ECLGS funds, based only on the end-use certificate, ignoring the forensic audit. So this raised a major concern about the procedural fairness and judicial scrutiny. The appellate tribunal, the NCLAT's ruling and reasoning was headed by Justice Ashok Bhushan and Mr. Barun Mitra. The appellate tribunal overruled the NCLT and made key observations. The first observation, inadequate consideration of the evidence, especially regarding the cash management agreement, CMA, which is crucial to understanding loan servicing. And another one, misuse of ECLGS funds was not established. The NCLAT noted the NCLT ignored material like the forensic audit. And third one, fresh default is equal to fresh cause of action. So the NCLAT clarified that res judicata didn't apply as the current Section 7 petition related to new defaults, particularly under the ECLGS scheme. As a result, the NCLAT set aside the CIRP initiation and directed NCLT to re-examine the case in the light of all submitted evidence. Why this matter? So what is the legal takeaway here? This ruling is important for several reasons. It reaffirms the adjudicating authorities must assess all relevant evidence, including audit reports and contractual agreements, before deciding on insolvency. It protects borrowers from premature insolvency proceedings, especially when accounts are not NPA and repayment are structured. It also clarifies that new defaults like those under emergency schemes such as ECLGS can create separate ground for CIRP. Finally, it reminds lenders and the resolution applicants to comply with due process and not rely solely on technicalities. If you found this video insightful, don't forget to like, subscribe, RR Corporates and RR Legal Talks. There are 2 channels, and share with others in the legal and business community. Thank you.